Hi, this is Marnie Carter, back with you today to speak with you regarding the federal rules in the California Electronic Discovery Act. As I made mention in my last video blog, the California Electronic Discovery Act, AB 5, became effective June 29, 2009. This new legislation expressly permitted the discovery of electronically stored information pursuant to California Civil Procedure Code Section 2031.010, subsection A and subsection E. This allows respondents to object to the producing of records that they deem inaccessible. It differs from the federal rules of civil procedure in that it differs in the way that it treats the accessibility of information and what is deemed as accessible versus inaccessible, as well as the provision of what has become known as quote-unquote safe harbor for lost information. The Federal Rule 26b2 deems reasonably inaccessible data does not have to be produced. A requesting party can dispute this assertion through a motion to compel production. The responding party can seek a protective order prohibiting production, but the burden falls on the responding party to articulate what concerns it has about the data which is being deemed inaccessible. If the requesting party shows good cause, however, the court may still order production. With our new California Electronic Discovery Act of quote-unquote inaccessible information, the California Electronic Discovery Act now assumes that all data is accessible. The burden is on the responding party to bring a motion for a protective order or to make written objections, as we have in the past with discovery. This is pursuant to CCP section, California Code of Civil Procedure section 2031.060, subsection C. The requesting party can bring a motion to compel electronically stored information that the responding party claims is inaccessible, and this is pursuant to California Code of Civil Procedure section 2031.310. California will permit discovery of this inaccessible information, but they still have to use your formal discovery procedures, as we always have, even with written discovery, in terms of the requesting party must bring a motion to compel, and the party that is opposing the motion to compel, the burden remains on that responding party to establish that the electronically stored information is inaccessible. This is pursuant to California Code of Civil Procedure section 2031.310, subsection D. And then finally, if the requesting party shows good cause, again, the court might still order production. However, the difference with California is they are interpreting many of the federal case law that we have encompassing the idea of sharing in costs. This has been something that wasn't specifically articulated when the federal rule amendments were put into place December 1st of 2006, but we've seen the judiciary really interpret this theory of cost sharing, and now it is explicitly demonstrated in the new California Electronic Discovery Act. This can be found at California Code of Civil Procedure sections 2031.060, subsection E, as well as 2031.310, subsection F.